Dear students, this is Naganand Edumudi. To get updates with regard to shorthand English, please subscribe my YouTube channel. My channel name is Naganand Edumudi. I am going to dictate a passage relating to shorthand, that is 100 words per minute. 5 seconds. Start. Before respondent number 3, according to him, by referring to matters incidental thereto, interlocutory application is not maintainable. On the merits of the matter, he contends that the petitioner does not have a vested right to restrain respondent number 2 from using or relocating plant and machinery according to its priorities. Respondent number 2, being a party before industrial tribunal, is bound by the order that is finally passed by respondent number 3. To prove the bona fides of respondent number 2, he draws the attention of the court to the amounts deposited by respondent number 2 by way of compensation to 57 workers who have not accepted the proposals of respondent number 2. He prays for dismissing the writ petition. I have heard the counsel perused the record. The short point that comes for consideration is whether the prayer of petitioner for interim injunction is maintainable and whether the rejection of such prayer by respondent number 3 suffers from perversity or illegality. The first contention of petitioner is that the order suffers from perversity. In support of his contention, he draws the attention of the court to the reasons recorded by respondent number 3 in para numbers 14 and 15, which are already extracted, and submits that this court can't be treated as either reasoning or conclusion in an order passed by the industrial tribunal cum labor court. Firstly, I would like to consider this contention from the perspective of the case pleaded by the petitioner. The prima facie case is always considered in the background of the right claimed by a party and how the right is established and the balance of convenience between the contesting parties. In case on hand, the substantial issue pending before respondent number 3 is whether closure of factory by respondent number 2 is legal and whether the petitioner is entitled and correct in demanding reopening the factory. This court is of the considered view that at this stage of the matter, the prayer is against restraining the respondent number 2 from removing the plant and machinery. Any case is expected to be made out vis-a-vis with reference to the plant and machinery, keeping in view the stand taken in the affidavit and the reply given by respondent number 2. Findings are recorded by respondent number 3. This court is of the view that the very fact that the findings now recorded and impugned are not rendered perverse merely because they are not in favor of petitioner. Therefore, though a ground is canvassed, this court is not persuaded to accept the first challenge of petitioner to the order impugned in the writ petition. It is further contended that if the plant and machinery is allowed to be removed and taken away, the valuable rights of workers of petitioners' unions are adversely affected. This court has already asserted the issues which are referred to respondent number 3 for decision. Issue number 2 deals with the relief that can be molded to 57 workmen whose details are enclosed to the reference order. Once the substantive prayer is pending before respondent number 3, it can't be contended that the refusal of prayer substantially defeats the right of members of petitioners' union. This ground is also not accepted and accordingly rejected. The learned counsel, though attempted to convince this court that under section 10 class 4 of the ID Act has to be read, keeping in view the objectives of both Industrial Disputes Act and also the right to life under Article 21 of the Constitution of India. I am afraid this contention doesn't fit into the facts and circumstances of the case. The right to file an application, particularly an interlocutory application, is one of the measures provided as part of procedure for decision by authority or court or tribunal during the pendency of the substantive prayer. The view of either the apex court or the other orders on which respondent number 2 is relying upon would amply make clear that the application itself is not maintainable. For all the above reasons, I am satisfied that the petitioner couldn't make out a case for interference by this court under Article 226 of the Constitution of India, and the writ petition fails and accordingly dismissed. The dismissal of the writ petition shall not be treated as this court expressing final view on any of the issues pending before respondent number 3. It is needless to observe that anything done during and in the course of pendency of ID is a matter of for respondent number 3 to consider while disposing of the ID. Respondent number 3 is directed to dispose of the ID within 2 months from the date of receipt of a copy of this order. No order as to cause. Stop. Dear students, this is Naganand Edumudi. To get updates with regard to shorthand English, please subscribe my YouTube channel. My channel name is Naganand Edumudi. I am going to dictate a passage relating to shorthand, that is 100 words per minute. 5 seconds.